Now we consider the remaining crimes against people, and we enter into our discussion of crimes against property. Now, the remaining crimes against people include a fairly long laundry list, but this material is tested much less than homicide. So we consider first the sex offenses, which include rape and statutory rape. Principally, there are others, but the big ones are rape and statutory rape. And here we consider a couple of specific details with regard to these crimes. Rape is a general intent crime, not a specific intent crime. And statutory rape is a strict liability defense. A strict liability defense. And here, once again, we see a direct connection between the law of torts and the law of crimes. We know in the law of torts that strict liability can arise either out of ultra-hazardous activities or as an element of products liability, strict products liability. And we know from the law of torts that plaintiffs favor this theory of liability because it doesn't require a showing of fault against the defendant. And here in the law of crimes, strict liability crimes are favored by prosecutors because a prosecutor does not need to show willful misconduct or some deliberate intent on the part of the defendant. All the prosecutor has to show is, beyond a reasonable doubt, the defendant engaged in specific activities. Here, the unlawful carnal knowledge of someone not old enough to give consent. Well, that's a strict liability crime, and a defendant who is convicted will be subject to full punishment. That's the most important thing to know about the sex crimes. Rape is a general intent crime. Statutory rape is a strict liability offense. Also, realize with regard to rape that consent is not a valid defense to rape where the consent is obtained through a trick, particularly a trick that might cause the victim to be unaware of the unlawful sex. And that's a fact situation that you're likely to see on a multi-state question. The remaining crimes against people include mayhem, which is causing a severe enough corporal injury perhaps to disable a victim or to cause the victim to lose a body part. That's mayhem. Next, we consider assault and battery. These are direct analogs to the law of torts, and the elements of assault and battery for crimes are strikingly similar to the law of torts. And we can see here that a defendant can face liability for these tortious actions in civil court and in criminal court. And in fact, the civil procedure ideas of res judicata and collateral estoppel can apply in this context also, where a fact has been litigated. There's a little bit of fine print to that law. I encourage you not to think about it a great deal, but when it comes up in practice, take a careful look at it. So, with regard to assault, the basic elements are either an attempt to commit a battery or the intentional creation of a reasonable apprehension of a harmful or unpermitted touching or some imminent bodily harm, and also the idea of aggravated assault. It's more serious than ordinary assault. And it's true in the law of crimes, just as is the case in the law of torts, that the more serious the conduct of the defendant, the more likely a charge will be escalated to something more serious, even if it has the same name. In the law of crimes, that escalation can come from the difference between a misdemeanor and a felony. The same conduct can give rise to either a misdemeanor or a felony charge, but typically the felony charge is supported by far more serious underlying facts than is a misdemeanor conviction. With regard to battery, we see again a direct analogy, almost an identical analogy, between crimes and torts. So here we've got an unlawful application of force, some bodily injury, or, again from the law of torts, a merely offensive touching, and then we can see also an aggravated battery. So with regard to assault and battery, we can imagine that conduct that would be considered socially not really acceptable could be considered a misdemeanor. But conduct that everybody would agree would be a serious harm would rise to the level of a felony. So assault and battery, This is tortious conduct. It also constitutes criminal conduct, and the degree of seriousness of the criminal conduct depends on the specifics of the facts involved. Finally, we turn to kidnapping and false imprisonment. False imprisonment is a tort cause of action that also can constitute a crime as well. The same basic facts are used to establish both torts and criminal liability for false imprisonment. The only real difference is the identity of the plaintiff. The victim is the plaintiff in a tort action. The state is a plaintiff in the criminal law action. Now, focusing on kidnapping for a moment, this is a charge that comes up with reasonable frequency both on the multi-state and on the essays. And basically what we have here is a situation where the defendant seizes the victim, moves the victim, transports the victim, and it can be a very short trip, but there still has to be some movement of the victim. That's the difference between false imprisonment and kidnapping, the actual physical transportation of the victim. The victim has to be concealed from public view and public access, and also there is the possibility of an aggravated kidnapping, again, identical to an ordinary kidnapping, except more serious. The facts become more grave. The kidnapping becomes escalated to a more serious aggravated kidnapping. Still, I think it's worth noting that all kidnappings typically are considered felonies. There's not really such a thing as a misdemeanor kidnapping in most jurisdictions. False imprisonment could be a misdemeanor or a felony. And again, we have to examine the facts to determine that. And one final detail with regard to kidnapping, a common mistake or a common assumption that we make that's not true. In order for there to be a kidnapping, all we need is for the victim to be seized and moved. There's no requirement that the kidnapper seek a ransom. That's an additional aggravation. It's an additional indicia of seriousness, but it isn't an element of the theory of liability. Well, that wraps up a very quick consideration of all of the crimes against people. Now we turn to consider the first, crimes against property. And here we're going to touch on all of the crimes against property that do not involve theft. The next video will contain all of our discussions about the various theft crimes. So, for our purposes in this video, the crimes against property that we're going to consider will include burglary and arson. That's basically it. Then we're going to go to consider the other crimes against property, the theft crimes, in a separate video. Now, as we consider burglary, here again, it's important to consider the distinctions between common law burglary and the modern statutory approach to burglary. Common law burglary had a definition that most of us found sort of interesting in a historical context when we first studied the law of crimes. Burglary involved the breaking and entering of the dwelling house of another at night. Well, that's a fairly rigorous definition, much more rigorous than the modern definition of burglary, which basically involves the breaking and entering of a protected structure. And as I discussed this, I left out an element of common law burglary, which was there had to be a breaking and entering of the dwelling house of another at night with the intent to commit a larceny or a felony inside. That's the elaborate common law definition, and the modern statutory definition is breaking and entering a protected structure with the present intent to commit a felony therein. So, on the multi-state, typically we are asked about common law burglary, and the presumption is common law unless we're told to use the modern approach. Now, as we consider the elements, breaking and entry, etc., we'll see through practice that the examiners are able to test our understanding of these elements in a fair amount of detail. The best way to learn that detail is through practice, and then annotate your outline with the additional details in the shortest form possible. That's the best way to strengthen your understanding of the law, and it's also the best way to appreciate fully how the material is tested. And being a savvy test taker is worth a great deal of points. Probably in most cases, it's worth enough points to make the difference between passing and failing. So, now we consider burglary, the breaking and entry part. Here, as we consider the entry, Suppose we've got a suspect who has been invited into the property. So the initial entry is done with consent. But then the defendant decides to go into an interior room that he or she has not been given permission to enter. There, we do have a sufficient breaking to establish a burglary, so long as the additional elements are all present. So the mere fact, and remember for essay purposes, anytime you want to denigrate something, refer to it as a mere something or other. Anytime we've got someone who enters the property with consent and then breaks and enters further within, that suspect is going to be liable for burglary, assuming the other indicia, the other elements, are satisfied. Also, it's worth being aware, even at common law, the breaking and the entry did not have to occur at the same time. We could have a breaking at one point, an entry later, and so long as the proper state of mind was present at the time of that entry, criminal liability for common law burglary will follow. Also, fraudulent entry is good enough to establish a breaking. So tricking somebody into letting you in is enough to satisfy the breaking element. Now, the protected structure issue. At common law, it was the dwelling house of another. Modernly, we just need it to be a protected structure. Remember, a defendant cannot be guilty of burglarizing his or her own home. At the same time, a defendant can be convicted of burglary for breaking and entering a home that he or she owns, but which is rented out to a tenant who is lawfully in possession. At that point, the landlord can be guilty of burglary if the other elements of burglary are correct. Now, as we focus on the intent element of burglary, there's got to be a breaking and an entry, but the defendant must harbor the intent to commit a felony within. And here, the specific intent to commit that crime must be present at the moment of entry. Now, suppose the defendant changes his or her mind after having entered. That change of mind is not enough to reduce the charge to trespassing, because at the time of the breaking and entering, the defendant had the right intent, and that's good enough to establish the burglary. The target offense within need not be committed. So if the defendant changes his or her mind, or if that crime is thwarted for some reason, that'll be enough for liability to attach. Now, finally, we turn to arson. That's the last crime against property that we're going to consider in this video. Remember, arson is one of two crimes that require the intent similar to that required of murder, and that is malice. Arson is a malice crime just as homicide is a malice crime. And so what we need is the malicious burning of a protected structure. That's enough for arson. And here, the fine points that are so commonly tested include where the defendant is able to burn the contents of a structure without damaging the structure at all. And smoke damage isn't enough. There has to be fire damage to the structure itself for arson to be provable. You only need to scorch the building, but if you fail to scorch it, you're not going to be guilty of arson. And that's basically it for a very quick consideration of the remaining crimes against people and the crimes against property that do not involve theft. In the next video, we will focus our attention exclusively on the crimes of larceny and the related offenses.